Our next speaker is the Honorable Cindy S. Matthias. She'll come on up. I'll let her get situated. I'll talk a little bit about her while she's coming up and getting her. Judge Matthias is actually from Michigan, and she came out this way in the late 80s, I think it was. And she has been an attorney since 1989. She was a prosecutor in Clackamas County. Prior to the time that she was a prosecutor and chief deputy DA here in Clatsop County for Steve Gertruck. She also worked in the North Marianas, which is a place I couldn't remember, Don. And she left the DA's office. Oh boy. They'd rather have donuts, but that's okay. I know. Judge Matthias has worked in private practice. She's worked as a prosecutor. She was chief deputy here, and she became a judge in 2000. And she was voted in 2006 and has been on the bench since 2007. So, 12 plus years. I think she's just starting her third term, as I recall. Did you ever practice law with your husband? No. Okay. I thought that was a dumb question. Oh, yeah. I got one that Judge Matthias probably doesn't remember, and she was my star witness in the case of State versus Andrew Betnar, who was a guide, fishing guide, and who was going through a divorce with his wife. And Judge Matthias was Mrs. Betnar's attorney, and as a mandatory reporter, she blew the whistle on him. And she was my first witness, I believe, in the trial we had about a long time ago. Anyway, Judge.
Wow. Well, thanks for having me. It's good to see everybody. I thought maybe
You can consider it or stand, whichever you
Oh, okay. I have some little props here. Thank you.
sit one, maybe.
I don't know.
You like
Maybe
the whole thing?
I'll sit here. Can everyone hear me okay? See me okay?
Yep.
I should move around though, because.
Do whatever you want. Just grab a mic if you move around.
Okay, so I've been asked to talk a little bit about officer in court, and so my first question, I suppose, yes, we can go to the first slide. Is, why do you care? You're on the street, you're doing your jobs, you're making your arrests, you want me to, here, I can do, just show me how. Just like this one? Okay.
We'll go to the next slide.
Okay, cool. Thank you, Crystal. All right. And so why do you care? And so I just am here to tell you that when you're called as a witness, everybody, judge, jury, audience, attorneys, are watching your every move. When you walk into a courtroom, you can hear a pin drop. And so everything you do, every motion, maneuver, scratch, you're being watched. And if that doesn't make you nervous enough, if you blow your testimony, then all of the work you did on the scene, all of the work that you did with your colleagues, all of the pain and agony that the victims and their families have suffered, all of the work that the DAs have done to, prepare the case and present it, it's going to be a waste. And you'll have done nothing more than a containment arrest. So if that isn't a lot of pressure, it is a lot of pressure. And so knowing, I can't sit down. So knowing and understanding the etiquette and the process and procedures is going to help you every time. And it's going to go a long way in calming your nerves and building your confidence, whether or not it's many of you are very experienced officers, but preparing every time is going to help you, whether it's your first time in court or whether you've been in court, dozens of times. So I have a few little tips, in no particular order. Oh, that's cool. I didn't do that. Pretty sure I didn't do that. Obviously, dress appropriately. Be clean, well-groomed, dress like you're going for an interview. If you're wearing your uniform, great. But even if you're an undercover cop and need to be rather scrunch, make sure that you're dressing appropriately. And get rid of these things in your pocket. When you're walking into the courtroom, it's like, a mile or two walk, and everything in your pocket is being picked up on our speakers. And wait a minute, I have a can of Altoids in here too, because those are the worst. You can hear every step. So get rid of your keys, get rid of your Altoids. Just give it a shake, or you can hear it as you're walking up to the stand. So get rid of stuff in your pocket. Get rid of a lot of, blingy things that are going to be distracting. Pardon? No. Oh, yeah. No. I'll say that too. No gum, and walk in confidently. Raise your hand for the oath and respond, confidently. Make eye contact with everyone you're talking to, and that's going to, you're going to present yourself in a confident way. Even if you're scared to death, nervous as all get out, hate public speaking, and all of those things, you have to fake it, and so just project that image. When you sit down, don't slouch. I know our chairs aren't really conducive to gun belts, but try to make sure that you're sitting up straight. So the next part is, that's really cool. Be serious. Be serious and respectful. This is not the place. Some of you will have court trials where there is no jury, and others will have juries, and so it's a different dynamic, but the same rules still apply. Beware of your behavior in the audience. It's not the time to joke around and look at your phones and giggle and do things that are distracting. People are watching you all the time. And if you're in the hallway, be careful about what you do and where you are, because you don't know who the witnesses are necessarily. You don't know who the family members are. You don't know if jurors are going to be walking in or walking out. You don't know who's seeing you. So you're kind of on stage even before and after your testimony. And so, it's not the time to, talk up people or check in with people or have lots of conversation, because, you don't know who's watching you. Always be respectful in your address. You'll address the judge as Your Honor, other people, yes ma'am, yes sir, Mr., Ms., whatever is appropriate. It's fine to call the defendant, but it's not wrong to identify them as Mr. So-and-so or Ms. So-and-so.
Just don't call them by the first name.
Yes, no first names, and a lot of officers do that, and it's especially if they know the person. But again, if you show respect for others, it'll help gain respect toward you. So credibility, obviously, is based upon what you say, how you say it, and body language is by far the biggest communicator. You can say all the things you want to, but if you're posed or if you're behaving in a way that shows disdain or disrespect, that's going to be what people hear out of your mouth. So, tip number 3. Don't chew gum. It's amazing how many people chew gum, even when they're waiting in the back to be called as a witness. Chomp, chomp, chomp. I know you're nervous. This is what I want you to do. I want you to get one of these, a stress ball. If you know you're chewing gums because you're nervous, do something else. Get a stress ball, draw something, but stop chewing gum. And if you think you're clever and can just tuck it up, you can't. We can see it when you're talking, and sometimes it moves and spits out. I mean, you have to not chew gum. So if you're doing that, stop it.
Judge, would it be contempt of it? There's a sign outside the door that says don't chew gum.
Yeah, it probably would be contempt. So the next thing is, where are you? Be prepared. Be prepared. Watch some trials, watch court trials, watch jury trials, learn the ropes. I mean, learn what the local rules are that may pertain to your case. Make sure that the court clerk is someone you have an ongoing, basis, ongoing friendship with, so that you can learn about the quirks of the courtroom, where things are plugged in. If you have electronics that you want to use for your case, especially if it's a court trial, call or stop by and check in advance to make sure that the court has the software program to present your evidence. Take a look at the jury instructions. I mean, if you're working with a deputy DA, they can show you some jury instructions that talk about credibility, how the jury, the trier of the facts, is going to weigh certain evidence. And so the things that the jury can use are the manner in which a witness testifies, his or her training, his or her experience. I mean, all of those things, that's you. And so learn. Review your report. You would be amazed at how many people, witnesses, police officers, don't review their reports before they testify. Sometimes they're out in the hall for hours waiting, and they come in, sworn in, sit down, and the first question is, Officer so-and-so, were you working on this particular date? And they say, well, let me look at my report. And then, so make sure you know your report. Learn everything about the case that you can, and before you come into court, kind of anticipate what it is you're going to be asked. Don't do this. May I refer to my report? Oh, yes. Okay. Let's see. Well, it's not on that page. Not on that page. Know your report. Know what's there. And please invest in a notebook, or spend, $1 or 50 cents, or, borrow one from the court clerk. Put your report in something that looks like you care. That you're professional, that you're testifying from something other than this thing wrapped up in your pocket. It makes a difference. When you're testifying, if you cannot recall something, ask permission to look at your report, or say, in order to be specific, I need to refer to my report. Every judge is going to let you do that. And so, so you don't have to memorize every little thing in your report, but do be familiar with it so you know where to find things. And go ahead and tab, put your report in a notebook and add some tags where you think, your testimony is going, so that you can flip to it, maybe highlight some things. And just remember, whatever you bring up to the witness stand is fair game. So the prosecutor can look at it, the defense attorney can look at it. So if you've got your, crazy notes, or you're writing something that, is not appropriate, or you're really, your true feelings about this case kind of thing, Don't put them into anything that you bring to the stand, because all of that stuff is fair game. Also, look for mistakes. Look for mistakes before the defense attorney finds them. And own up to them. If you made a mistake, if you put the wrong date, if you had the wrong information, if you transpose numbers, or if, mistakes aren't the end of the world, but hiding them is going to just crush your credibility. Don't talk over people in the courtroom. So, for example, if a judge or an attorney starts talking and you're in the middle of something, stop. If you hear objection, stop. Let there be discussion and wait for permission to resume. If something has been sustained and you're not allowed to talk about that, and you're still not clear if you're allowed to talk about that or not, just ask, am I allowed to go on with my statement? Or get some clarification. And while all this is happening, remain calm. You can't help anybody, especially your case, if you lose your temper. You're going to harm the credibility of your testimony, and even if you have strong feelings about the case, strong feelings about the parties, keep your cool. Keep your cool. Even if you have to literally bite your tongue, and don't say what you want to say. Just stay calm, stay cool. As a police officer, everyone is expecting you to be tough, to have a tough skin, to be able to take some tough questioning and a little roughing up. And if you don't lose your cool, you're going to lose your credibility. And if you're the one being calm, polite, respectful, then at some point the jury is going to be really mad at the person who's trying to attack you. Oh, my new phone. All right, another thing, obviously, take a deep breath, tell the truth, take your time, think before you speak, look at the judge, especially if it's a court trial. Look at the jury if it's a jury trial. If somebody asks you a question and you really don't know, don't look at the prosecutor for help. It's like, help me. Don't. Do your best. Calm down. If you need to regroup because you are scrambling, can you repeat the question? Is a great time saver. And you are on the stand to relate the facts. Be sure to, unless you're asked specifically for your opinion, don't give your opinion. Talk about your observations, and don't make your case any better than it is. So don't exaggerate. It is not a flaw to not have a perfect case. And really, the best police witnesses are those that don't try to make the case any better. That's what the trier of fact is supposed to do. They're supposed to figure out what the facts are and determine whether or not the elements of the crime have been breached. So again, if listen and answer as carefully as you and fully as you can. If you need clarification or if you need a moment to regroup, ask for a new question, and after you have answered the question, stop. If you're a person that rambles, stop talking at some point, because if you just go on and on and on, you're going to lose anything valuable. And I'm rambling, so that's a perfect example. Stop rambling. If a yes or no answer can suffice, then yes or no is what you should say. You don't have to go on and on. Obviously, answer all of the questions truthfully. Here's something that happens a lot where I think officers get kind of stumped because they're asked by the other side, who have you talked to about this case? Or have you talked to anybody else about this case before coming into court today? And your gut reaction is, well, no. I mean, it would be wrong to talk to somebody. But if you think about it, there's nothing wrong with talking to people about your case. You could certainly say, I talked to the prosecutor before coming into court today, or I talked to my fellow officers to make sure, that I was prepared. I mean, there's nothing wrong with that. So be truthful, and if you talk to somebody, say so. There's nothing wrong with that. But I see that, kind of rattling people, and so don't let that rattle you. I've already talked about ask for clarification if you don't understand. This is so slick. And modify your statement if needed. Maybe you've gone on with the questioning and you realize that you made a mistake or you misspoke. And if you believe your statement is incorrect or you did not accurately reflect what happened, correct it as soon as you can. You can ask for permission to clarify a statement you made because you do not want to mislead the jury, you do not want to mislead the judge, and explain why you were incorrect or explain what the correction is. There's nothing wrong with that. So try to correct any errors in your testimony as soon as you can. Speak plainly. For example, you're operating an official government vehicle. How about a patrol car? You exited the car. Well, how about you got out, or the defendant got out? The defendant took flight. They did. How about say they ran? They were apprehended. Well, why did you say, they got caught? Instead of proceeding, you went somewhere. Surveilling, you watched somebody do something. You were advised. You were, somebody told you something. So try to speak in plain language. Tell the story using your observations instead of your conclusions. If you believe someone is nervous, because we all know that being nervous equals being guilty, right? But if you observe someone being nervous, say what you observed. Oh, they were sweating, or they were looking at their clock, or their eyes were darting around. They couldn't sit still. Those kinds of things. Talk about what you observed. It makes it much more interesting and colorful for the listener. And it's more descriptive than just saying nervous. I mean, we don't know what everyone thinks nervous is. Also, if you need to use profanity, it's really, I think, to your best advantage to let the court or the jury know that some profanity is coming up. For example, well, not for example necessarily, but what it does is if you say, well, I approached the defendant and I asked if I could go into their house, and he said no, but he used some profanity. May I say exactly what he said? And the court would say, well, sure, what did he say to you? Well, he said, F you, kind of thing. But what it does is it helps set out just sort of the indecency of the language and the indecency of the conversation. So we have some witnesses will just, and even some police officers will just, say what a defendant said, and it's filled with, lots of F-bombs and this and that. And I think you lose some of the effectiveness of that testimony if you don't say, well, he spoke to me, but he had a lot of profanity, or he said a lot of foul language. I have a direct quote here. Can I say it? And then everyone's sort of ready for it, and they kind of agree with you that it was out of line. Some of these are super easy as far as what common sense would tell you. Don't guess if you don't know an answer, or if you don't have a response. Don't speculate on things that you don't know. Avoid saying something like, well, I suppose so, when you don't know, or I think so, or sometimes a defense attorney will say, hey, blah, 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 and you would say, oh, if you say so, kind of thing, like taking someone's word for something. Try to avoid that. That's, kind of evasive. Don't volunteer information. So again, if you have answered the question, stop talking. Don't jump ahead. Don't fill in the gaps by providing information that you were not specifically asked. That's the prosecutor's job, to help, build the story, to help move the testimony along. You may be thinking that, you're doing a great service just by going on and on and on, but sometimes you open up areas for cross-examination which wouldn't have been available had you just answered the question. So let the prosecutor guide you with their questions. There may be an exception if it's a court trial and there's something that no one's going to ask you because you're testifying on your own, but you think would be important, especially in some of the fish and game scenarios where there may be some regulations, or there may be something about an observation point by a river, or there may be something about an intersection. Say, I would like to explain a little bit about what I was doing there, what that intersection looks like, so that the trier of fact can understand this following testimony. So other than that, don't volunteer information. Watch for traps. You need to understand truly the role of the defense attorney. Their job is to zealously advocate for their client. Their job is to poke holes in the state's case. Their job is to show bias. Their job is to create distractions from the evidence. It's their job. Everyone has a constitutional right to a defense. Or to be defended. They have a constitutional right to make the state prove the case beyond a reasonable doubt. So it's not a moral failing of this attorney who decided to be a defense attorney. It's their job. So don't hold them in contempt for trying to, get at you. But just recognize some of the traps. Remember who is on trial. Watch your mindset. Don't get defensive, because defensiveness will detract from your credibility. Be prepared to distinguish, for example, that you receive training on how to testify professionally. There's nothing wrong with that. Don't be ashamed of it. You received training on how to testify professionally and how to present information logically. That's part of your training, which is different than being trained on how to sound believable. Well, it's true, isn't it, that at the academy you had some training on how to, present yourself in a believable manner. No, you had training on how to present yourself in court and how to present information logically. So watch for traps that might kind of twist what it is that you actually have learned. Demands for yes and no responses can be really difficult. For example, something like, officer, isn't it true you neglected to lift the plates or the fingerprints off of this plastic bag? And it's like, well, yes, no, and the reality is, well, maybe that you can't lift prints off of certain surfaces, and you can't answer yes or no. And so if a yes or no is not going to be enough, you should say, well, I cannot answer yes or no without misleading the jury or without misleading the court. And so that lets the jury know that, hey, this defense attorney might be trying to, hide something. And so don't fall for the trap if you cannot answer yes or no. And if the judge says, well, just answer the question, yes or no. And some judges will do that, just say answer yes or no. And so then it's the prosecutor's job when they come back on redirect to have you develop that more. Oh, you seem to struggle when you answered yes or no. Is there something more you wanted to say on that point? Then you can explain yourself. Also, don't be defensive when defense attorneys ask you about being paid. Well, isn't it true you're getting overtime because you're testifying here today? Well, if it is, hey, I work nights, so I usually sleep during the day. If I'm called to court, it's overtime. There's nothing wrong with that. Or you can say, I get paid the same, whether it's a guilty or a not guilty, or I get paid the same, whether I'm on the street or in court. There's nothing wrong with these things, so don't let a defense attorney try to get you to get riled up if they're asking you, you're paid today, aren't you? Suggesting that you have some sort of incentive to be there in court. And watch for repetitive questions. Usually the prosecutors will object if the same question's being asked over and over again, but there are ways to ask the same question in a different way, and that happens quite frequently. So just be careful, because the goal is to find some inconsistencies in some of your testimony and to trip you up. So respect is really the key to all of this, and to keep you cool. And so you have in front of you a Q-tip. Remember the Q-tip? Quit taking it personally. Quit taking it personally. It's not you. It's your role, it's your job, and it's not personal. So if you're feeling all emotionally whipped into a frenzy, just quit taking it personally. There are some other tricks and maneuvers that I'll mention too. Sometimes defense attorneys will mispronounce your name over and over again, or they'll mispronounce a victim's name over and over again, or something related to the case as a way to kind of tick you off and get you distracted. Just ignore it. If they keep doing it, the jury's going to be mad at them. They might try to get you to argue. Ignore it. Be polite, because your polite demeanor will win the hearts of the jury. They might try to misstate your previous testimony, so make sure you listen to their question and don't let them put words in your mouth. They may try to quote your previous testimony and ask why it wasn't included in your report. How many of you have faced this? That was important, you would have put it in your report, right? And so, you can honestly say, I put in my report information that I thought was important at the time. It doesn't include everything. You're not a computer. We have more video these days, which I think puts a damper on some of those questions. But honestly say, I thought this was important at the time. I put it in my report. If I had seen that at the time, I would have put it in my report. I didn't think to include it. It didn't seem important at the time. There's nothing wrong with that. And just remember, those reports are to help you remember your testimony. It can't possibly have every single little detail. Have you ever seen a defense attorney in a jury trial especially walk away from the jury and have you follow them to talk, and the jury's over there going, hey, we're the trier of fact. So sometimes defense attorneys will do that. They will have you go with them somewhere else. Watch that and listen to their question, start to answer it, and then go back to the jury, because the jury needs to hear you, and you need to talk to the jury. So it doesn't have to be, just try to make it natural, but don't let the defense attorney move you away from who you're supposed to be talking to. Sometimes attorneys will try to get you to do two things at once. Well, officer, can you come down here and draw a chart of the intersection here so we can get an idea? And so, you get down there and no one's an artist, and they get out the pen and the paper, and they start to draw, and then all of a sudden the defense attorney starts asking questions, blah, 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 and then you're like, wait a second, I put this dot here. And so don't do two things at once, because that's a very common trick to try to get you flustered, to try to get you confused. Stop drawing, answer the question, and then go back to your drawing, kind of thing. And so don't let the defense attorney move you in ways that are going to confuse you, derail you, make you forget things, lose your place, that kind of thing. Just stop and take it back and listen, and then go forward. When they question your experience, be proud of your experience. Hey, if you've been on the street for 6 months? I've been on the street for 6 months, you know? Even if you've been on the street for 20 years. Don't let anyone try to question your experience. Embrace it. Here, I better put that up there. Embrace your experience. Oh, there's another one. Don't you come. But in your notebook, you know, have a trial notebook. Have your resume in it. Have your training and experience, you know, the conferences that you've been to. Keep an up-to-date resume in your trial notebook because it looks really, really cool when a defense attorney will say, well, officer, when was the last time you had your training on blah, blah, blah? And you could say, well, let me check my resume. And then you can go in your notebook and say, well, I went to this one and I went in 19, you know, whatever, and I went to this one in 2000, whatever. And it looks really professional. So keep your credentials. You don't have to have every certificate, but, you know, at least have a resume. Or something that you can refer to that helps you identify your particular training. And if you don't have training in certain areas, there's nothing wrong with that. You can't do everything, you know, and if you don't have training in certain areas, don't say that you did. Okay, so,
I've got to get this done by
yeah,
5 o'clock,
okay.
so I'm going to cut you off soon.
Don't you gum. So let me just see if there was anything else. Oh, here's another one, just real quick. A defense attorney will say, well, I'm looking at this paper, officer, and, you know, isn't it true that you can consume, you know, 5 ounces of alcohol before your blood levels rise? And so sometimes officers will say, or the witness will say, well, if you say so, or if it's on that paper, it must be true, kind of thing. The oldest trick in the book is to hold it, you know, read something from something that purports to be an authority and have you try to agree with it. Don't agree with things if you don't know what it is. And so I think there's lots of other little tidbits, but I think you get the drill. Respect, calm, cool, collected, prepared, you know, that's how you are going to, you know, be a credible witness, whether you win the case or lose the case. Your integrity is the only thing that you need to, you know, fight for and preserve. So that's it.
Thank you very much.
Questions? Okay. All right.